Okay, well, good afternoon, everyone, and welcome to this seminar, which hopefully now we can start, on lost lives and lost years, in which we'll be taking a closer look at the complexities that can sometimes arise in relation to loss of income claims under the Fatal Accidents Act, which I'll be dealing with, and the lost years doctrine, which will be dealt with by my esteemed colleague, John McDonald. In particular, we'll be looking at claims where the income that has been or will be lost as a result of the deceased's death stems not from a normal salary, but from directorships and dividends. Now, we do have quite a lot to get through today, so we might not have time for a question and answer session at the end. But if you are left with any questions, both John and I would welcome your emails at the end of the seminar. So with the housekeeping done, let's turn to the Fatal Accidents Act 1976. And before we descend into the nitty-gritty of dependency claims, it's worth taking a moment just to orientate ourselves in that act. So the starting point is that the Fatal Accidents Act provides for two types of claims. The first is that it provides for a bereavement award to be paid to certain relatives of the deceased. And second, it provides for dependents of the deceased, as defined in the statute, to recover a claim for their loss of dependency. Now, if I'm honest, bereavement awards are really not very interesting, so we won't delay there for very long. But I'd like to pause just to note that bereavement awards can only be made in respect of a very narrow class of people. Broadly speaking, this is spouses and civil partners, parents where the deceased child was unmarried, and in certain circumstances, long-term cohabitees. Now, as we'll see, this category of people who can claim a bereavement award is much narrower than the equivalent category of dependents for the purposes of a dependency claim. And that's really all that there needs to be said about a bereavement award. And so let's move on to the second type of claim that can be brought under the Act, the dependency claim, because that gives us far more to get our teeth into. There are two requirements that must be satisfied if a loss of dependency claim is to succeed. The first is the person on whose behalf the claim is brought must fall within the statutory definition of a dependent, and that's in sections 1.3 to 1.5 of the Act. Now, note, I carefully didn't say that the claimant must satisfy that definition. And that's because, as a general rule, claims under the Fatal Accidents Act have to be brought by either the executor or the administrator of the deceased's estate. That's in section 2. That means that the claimant noted on the claim form might not actually be a dependent, nor do they need to be, as long as the claim is brought on behalf of someone who satisfied the statutory definition. And that definition is reasonably broad and covers most family relationships, either by blood or by marriage. However, that list isn't limitless. And if the putative beneficiary isn't on that list, then the fact that in reality they're financially dependent on the deceased is neither here nor there. They still can't establish a loss of dependency claim. But similarly, if they are on the list, that itself isn't sufficient to make out the claim, because they still need to satisfy the second requirement. And this is that the dependent must show that they've suffered what the statute terms an injury as a result of the deceased's death. Now, despite that quite broad phrasing, in practice, what we mean by injury is a pecuniary loss, and that's a concept we'll come on to shortly. But to finish off our overview, once these two requirements have been satisfied and a loss of dependency has been established, the court has to turn to the question of quantifying the loss. And that itself isn't straightforward, as we'll shortly see. So now we have a renewed sense of the mechanics of the Fatal Accidents Act. It's time for us to look a bit closer at the requirement that the dependent has suffered a pecuniary loss. Now, there's a crucial thing to remember here that is both very obvious in one sense and also very easy to forget. And that's that a dependency claim is not a common law cause of action. It's a creature of statute. Now, this means that it can create outcomes that, if we look at them through the more familiar common law lens, can seem both counterintuitive and, in Lord Diploc's words, wholly artificial. So keeping that always in mind, when we consider the question of pecuniary laws, there are three overriding principles to be gleaned from the authorities. Now, while these principles might be a little bit fuzzy around the edges, they're based on common law authority and for the Court of Appeal authority, and for the moment at least, they are well settled. So in summary, these three guiding principles are: first, that the court cannot take into account any benefits that the dependent has received as a result of the death when determining dependency. Second, that the dependent can't, by their own actions, increase the size of their dependency claim post-death, or indeed decrease it. And third, that a distinction has to be drawn between income derived from labour and skill on the one hand, and income derived from capital assets on the other. And we'll look at each of those in turn. The principle that the court must ignore all benefits which accrue to the dependent as a result of the death comes in the first instance from Section 4 of the Act. Section 4 reads, "In assessing damages in respect of a person's death in an action under this Act, benefits which have accrued or may accrue to any person from his estate or otherwise, and as a result of the death, shall be disregarded." In other words, any benefit at all that is triggered by the death, whether that be a life insurance payout or an inheritance, or even crowdfunding to support the deceased's now orphaned children, must be ignored by the court. Now, this can lead to some rather counterintuitive outcomes. And to give you a sense of how frequently this crops up in practice, just this week, I was involved in a case of a dependency claim brought by a widow. And that claim was, in part, for her future loss of dependency on her deceased husband's pension income. Now, under the terms of that pension fund, on the deceased's death, the value of the pension, which was not too far off £500,000 when he died, was transferred to the widow. Pursuant to Section 4, this transfer had to be disregarded, even though that sum of money was precisely what would have generated the couple's retirement income. And indeed, for the widow, it could still do so, albeit at a lower level, if she reinvested it into a new pension fund. However, because of the operation of Section 4, this sizable transfer couldn't be deducted from her loss of dependency claim. And so her claim was worth £500,000 more than, as common lawyers, we might think it should be. Turning to the second principle and the date at which dependency is assessed. It's often said, including by the court, that dependency is fixed at the point of death. And that's true as far as it goes, but it is a potentially dangerous oversimplification. Because as Lady Justice Smith and the trial judge in the case of Williams and Welch ambulances recognised, there are some things that the court is expected to take into account. So how do we draw the line between post-death occurrences that the court should ignore and post-death occurrences that the court has to consider? Well, in my view, the best way to conceptualise this distinction is to draw a line between changes that would have happened in any event and changes that flow from choices made by the dependents following death. So a recession which decimates the deceased's industry, and so would have reduced the family income even if he had survived, should be taken into account by the court. The court isn't obliged there to ignore that external reality when it comes to assessing dependency at trial. Similarly, if the dependent has died before trial or received a terminal diagnosis, the court doesn't have to pretend that they have a normal life expectancy, and so award damages going into a future that, on the balance of probabilities, the dependent is just not going to have. But in contrast, if the family business is taken over by new management in the aftermath of the deceased's death, and that then leads to an increase in profits, that change cannot be taken into account by the court because it flows from a choice triggered by the deceased's death itself. And this explains the outcome in Williams and Welch ambulances. The deceased had run a very successful family business just before he died. After death, the management of that company was taken over by his children and his widow. And in fact, the new management did spectacularly well, and the profits of the company increased significantly. However, despite the fact that the dependents were all better off than they had been when the deceased was alive, the court still found a valid dependency claim because the actions of the dependents following the death couldn't be taken to change their legal entitlement. Now, as we'll see, the characterization of what should and what shouldn't be taken into account by the court is up for discussion in the outstanding appeal in the case of Ricks and Paramount Shopfitting, which we'll come on to later. So to a degree, we need to watch this space going forward to see if these principles will remain the same. Now, turning to our third and final principle, the court has to separate out income derived from ownership of capital assets from that income which is generated purely by the deceased's own hard work. Now, there's a spectrum here where both ends are clear and the middle gets a bit murky. So at one end of our spectrum, matters are straightforward if all of the deceased's income was derived from their ownership of assets, and those assets have now passed to the dependent. So assume that our deceased is an old money millionaire whose income is derived solely from his ownership of vast tracts of the British countryside. Now, when he dies, that property passes to his dependent widow, say, then she steps into his shoes as the recipient of the income, and the income continues unchanged. Now, in such a case, the widow cannot sustain a dependency claim under the Fatal Accidents Act. As explained by Lord Justice Beldam in the case of Wood and Benthall Simplex, the claim doesn't fail because of Section 4. It's not that the court, or not just that the court, has ignored the inheritance under Section 4. The claim actually fails at an earlier stage. It fails because no loss has been established. Now, to see why this is the case, we can use one of my favourite legal analogies, which was coined by Lord Justice Stoughton in Wood. Now, he said that income from assets is like having an egg-laying goose. So your goose is your capital asset, and then the eggs that it periodically lays are your income. If, following the death, the dependent now owns the goose, then they can't complain that they've lost out on eggs. So that's one end of the spectrum. The other extreme is also quite clear. So where there's no capital assets to speak of, but only the deceased's labour, so say the deceased is a successful singer and all his income comes from his performances, then all of that income potentially needs to be taken into account. The problem comes where income is derived in part from labour and in part from assets. Now, if capital assets are best thought of as a goose, then I like to think of situations where there's a mixed derivation of income as a pasta machine. Bear with me. So unlike a goose, a pasta machine doesn't produce pasta, our income, on its own. It requires external input from someone cranking the handle. So if the dependent could reasonably have expected that the deceased would continue to turn that handle, then they've suffered a pecuniary loss, even if they inherit the pasta machine itself. That asset is only valuable because in some sense it channels the work of the deceased. Now, this was exactly the situation in Wood. The deceased was a farmer who owned assets that formed part of the family farm. But he also worked very hard in improving that farm and therefore the value of the assets. On his death, his dependents inherited the assets and continued to receive income from them. However, the court found that because the value that the dependents had been receiving before the death was in large part due to the deceased's hard work and not just a passive holding of the farm assets, then there was a valid dependency claim. Now, as I've said, the application of these three principles can lead to some counterintuitive results. Indeed, it's entirely possible and reasonably common that a dependent might have a good claim for loss of dependency, despite the fact that in the cold terms of pounds and pence, they are better off than they were when the deceased was alive and still supporting them. And this comes through particularly strongly where the deceased was not in what we might call normal employment, but was in some sense an entrepreneur. Now, this type of dependency claim was considered by the court most recently in the case of Ricks and Paramount Shopfitting. Now, Ricks was a High Court case which was decided last year, and it provides a useful illustration of the three key principles in action. So to briefly outline the facts, Mr. Ricks, the deceased, was exposed to asbestos when he was working for the defendant's company in the 1970s. While he was still in his early 20s, he left that job and set up his own business, which was very successful. And by the time he died, his business had a turnover of about £1.5 million. Now, that family business was set up as an incorporated company. The deceased himself owned 40% of the shares, as did his wife, the dependent. The remaining 20% of the shareholding was split between the couple's two adult sons, who both worked in the family business alongside their dad. As well as her shareholding, Mrs. Ricks also was named as a director of the company and drew a director's salary. However, she didn't take any material role in the running of the business. Her sphere of activities was and always had been very much the home. Following the deceased's death from mesothelioma, Mrs. Ricks inherited his shareholding and so became the majority shareholder. Day-to-day running of the company was taken over by one of the two sons, and under his guidance, the company became far more profitable than it even had been during the deceased's lifetime. Now, against that backdrop, Mr. Justice Kavanagh found that taking a pragmatic rather than a legalistic view, Mrs. Ricks's income should be attributed to the deceased. Although she received the director's income and the dividend income in her own name, he found that the money was realistically the fruit of his labour and not hers. Therefore, it should be treated as part of his income from the company and not treated as a separate income for the purposes of dependency. He went on to find that had the deceased survived, Mrs. Ricks had a reasonable expectation that he would continue to work in the company and therefore continue to generate an income for her benefit. Now, when he died, this expectation was frustrated. The handle on the pasta machine stopped turning. Therefore, because of this, there was a valid dependency claim, even though Mrs. Ricks was financially better off than before her husband had died. Now, in light of that slightly counterintuitive finding, Mr. Justice Kavanagh then had to decide how best to quantify the loss of dependency. In considering this question, he emphasised that the assessment of dependency was, back in the old days, a jury question. Now, while assessment of dependency is now not carried out by a jury, but by a judge sitting alone, the court retains the broad discretion that the jury would have had in choosing whichever method of assessment they feel best does justice in a particular case. So the court has to use all the information available, along with a healthy dose of common sense, to come to a bespoke assessment on the facts before it. Now, the three principles that we've already looked at apply to the question of quantification just as much as they do to the question of whether a dependency has arisen at all. And of particular relevance is the principle that the nature and size of the dependency is fixed at the point of death, at least as far as the dependent's actions are concerned. For this reason, it isn't permissible to compare the actual fate of the business after the deceased's death with a projection of how it would have fared had he survived. Now, this was expressly rejected by the court in Ricks because this approach necessarily takes post-death choices of the dependent into account. But beyond these principles, the court can largely assess dependency as it sees fit. And two potential approaches were advanced by the claimant in Ricks. Now, giving a moment to basis 2 first, and because basis 2 was the basis used in all of the previous Court of Appeal cases of Wood, O'Loughlin and Williams that the judge had relied on in his judgment. Now, under this approach, loss of dependency is assessed as the cost of replacing the deceased's labour and skill at a commercial rate. In other words, how much do you have to pay to hire someone else to fill the same role as the deceased was filling to the same standard that the deceased was filling them? Now, as was noted in Williams, this can be particularly useful where we need to separate out income from assets from income generated by labour, because the cost of replacement in effect becomes a proxy for the value of the deceased to his company. So that was basis 2, but basis 2 was advanced as an alternative. Basis 1 was what the claimant really wanted. Basis 1 suggests that the value of dependency was equal to Mrs. Ricks's share of the joint income that would have been drawn from the business if the deceased had lived. Now, this is potentially much higher than basis 2, but it was preferred by Mr. Justice Kavanagh on the grounds that the loss of dependency in this particular case arose solely from income produced by the deceased's labour, and therefore there was no element of asset-based income to be stripped out. Now, at first blush, that seems a bit strange, because what are shares if not assets? But in essence, it seems what the judge was deciding was he, in effect, declined to treat shares in the company as inherently income-producing assets. Unlike property or land, the value of the shares was intimately bound up with the deceased's own work and skill. Therefore, they shouldn't be assessed as a source of income on their own, separate from the deceased's work. The two are intertwined, like our pasta machine. Now, as a result of the court's decision, Mrs. Ricks was awarded the income that would have been drawn by the company, from the company, by herself and her husband, had he not died. Now so basis 1. Now that figure was reduced by a percentage to reflect the amount of money that the deceased would have spent on himself alone, but was still a very significant sum. So a good outcome for Mrs. Ricks and for claimants in that case, but the matter doesn't rest there, because in February this year, the deceased was granted permission to appeal. Now, the application containing the grounds of appeal isn't publicly available, but if anyone fancies some light watching this evening, that the permission hearing is available on the Court of Appeal's YouTube channel. And having watched that, what we can glean from it is that there are 3 grounds of appeal, where grounds 2 and 3 overlap really very closely. Now, the first ground is the defendant's objection to the court's adoption of basis 1. The defendant is highlighting that none of the previous Court of Appeal authorities have assessed dependency on this basis, which is true, although query why and to what extent that fetters the discretion of the High Court. But the more fundamental point that the defendant is making here is not just that the quantification is wrong, but that when looked at properly, Mrs. Ricks hasn't actually suffered a loss of dependency at all, and so the claim can't be established. In the defendant's view, she does own the goose that lays the eggs, and the court cannot ignore the fact that her reasonable expectation of income has in fact been realised even after her death, or his death. Now, grounds 2 and 3 are linked to ground 1 and very closely with each other. Here, the defendant is objecting to the fact that the 40% shareholding in Mrs. Ricks's name and the income that was derived from that was attributed to Mr. Ricks. Now, it's being argued that it's illegitimate to treat this income as his and not hers, because that ignores the legal reality of the situation and the choice that the deceased made in the setting up of his company. Because this income was attributed to Mr. Ricks at the trial court, it means that it didn't need to be deducted from Mrs. Ricks's loss of dependency, as it would otherwise have been if she'd have earned that money on her own account by working outside the family firm. Permission was granted to appeal on all 3 grounds, but it has to be said somewhat reluctantly. And for my money, the defendant will have an uphill struggle in winning this appeal, as the trial judge did seem to be following Court of Appeal authority and the provisions of the Fatal Accidents Act. Now, the strangeness of the outcome, in my view, is less because the case was wrongly decided on the law as it stands, but that this area of law has developed in such a way so that it doesn't sit nicely alongside our normal common law principles. But you won't be left with just my views on this for much longer, because the appeal in Ricks is listed for the 23rd of June this year. So very soon, we'll hopefully have a definitive answer. Now, before I hand you over to John and the wonderful world of lost years claims, there are a few practice points that can be isolated from our overview of the Fatal Accidents Act. Looking at the dependent first, if you're representing the dependent, always remember that dependency claims can be brought in respect of any loss that can be quantified in money or money's worth, even if that dependency would have existed entirely in the future. Now, this means that pecuniary losses aren't limited to the classic claims of loss of income and loss of services that tend to be advanced. So think, for example, did the deceased have health insurance as an employment perk that extended to cover his family? Because if he did, then the dependent will have had a reasonable expectation of private medical care that they now will need to pay for. Perhaps the deceased had a company car that their family could make use of, or maybe the deceased was allowed to collect air miles when he was travelling for business in his own name, so he could use them to provide holidays for the family. Dependency claims can also be broader temporally. Now, there's no requirement that the dependency claimed for has to exist at the point of death. So claims can exist on behalf of dependencies that would only mature in the future. So, for example, parents can claim for care that their deceased child would have provided in the parent's old age, or as unyet married children could claim for contributions that the deceased would have made towards the cost of any future wedding. Now, of course, the further into the future that these dependency claims would have arisen, the more speculative they are, and so the harder they are to prove, which just goes to emphasize the need for thorough, witness evidence to substantiate the claim. However, there is no reason in principle, if the facts are right, why these matters couldn't be claimed for. The other point to notice, which again is a reasonably obvious one on some grounds, is that forensic accountancy evidence needs to be very thorough and obtained as early as possible. And if it can cover both basis 1 and basis 2 type awards, as well as any other basis that you might see fit, then that will set you in good stead going forward. Flipping to the other side, if you're representing the defendant, then really use the flexibility afforded to the court in assessing the dependency. Really interrogate what his role in the company actually was. So imagine a case where the deceased still worked in the business, but he wasn't providing any sort of driving force. And perhaps the profit had been stable in the preceding years. If that company keeps running at the same level of profitability after his death, then you can argue that there's been no pecuniary loss at all. We are in a goose situation and not a pasta machine situation. Now, this argument was tried in Ricks and it failed. But it failed not because it isn't a good argument, but because the facts were wrong. In that case, the business was very much in the process of expanding when the deceased fell ill, and he was really at the centre of that development plan. Similarly, if the business is growing in a new direction that it hasn't covered before, then it might be possible to argue that the deceased would have required expert assistance in that new field, even if he had survived, and that can be used to reduce the value attributed to the deceased's labour. And that was seen in the case of Grant. Now, that's all I have to say on the Fatal Accidents Act, and it's been somewhat a whistle-stop tour. And so if you do have any questions, then please do drop me an email. I'm always very happy to answer them. But for now, I'll pass you over to John McDonald to deal with lost years claims.
Thank you, Paige. In order to understand the interesting recent decision in Head and Culver Heating, we need to go back to the origins of the lost years claim. Many torts kill people either outright or by shortening their life expectancy. The classic case is one where the victim contracts mesothelioma as a result of asbestos exposure. They start to suffer symptoms many years later, and sadly their death follows shortly afterwards, usually within a year or two. They may wish to bring a claim in their lifetimes, either because they have no dependents for whose benefit a fatal accident claim could be brought, or simply for their own peace of mind. If there had been a fatal accident claim, they could have included an income dependency claim based on a proportion of the income which they would have earned had they lived. It used to be questioned whether a similar claim could be brought by the victim himself in respect of the lost years. That's to say, the years of life he has lost as a result of the tort. An attempt to bring such a claim was made back in the 1960s in Oliver and Ashman, but was rejected by the Court of Appeal, with Lord Justice Holroyd Pierce stating that, and I quote, "Nothing is of value except to a man who is there to spend or save it." Pickett was in effect an appeal against that decision. In the intervening years, the High Court of Australia had allowed a lost years claim, and in the event, a majority of the House of Lords was persuaded to allow such a claim here. But as we shall see, the court labelled such a claim one for an existing capacity to earn in the lost years. And that's an important touchstone as to how to deal with these cases. The claim considered by the House of Lords in Pickett was a loss of earnings claim, so that they didn't address their minds to claims for other losses in the lost years. In particular, they didn't address the difficult question of how to draw a distinction between earned and unearned income. The first case, at least one in an appellate court which considered that issue, was Head and Culver Heating. Why are lost years claims needed? One of the reasons why the House of Lords in Pickett allowed a lost years claim is a technical one. As Lord Wilberforce noted, if a claimant brings a claim in his lifetime which proceeds to judgment or is settled, that will bar a fatal accident claim after his death, because there's only one cause of action, and there's been judgment in that cause of action. Conversely, that means that there cannot be claims in respect of the same tort, both for lost years and under the Fatal Accidents Act. In 2005, in Gregg and Scott, Lord Phillips suggested that the best solution would be for legislation to do away with this lost years claims altogether, allow a claimant to bring a claim for everything other than loss of earnings in the lost years during his lifetime, and amend the Fatal Accidents Act so as to allow a claim for income dependency to subsist despite his recovery of damages for his injury. That would accord with what Lord Salmon said in Pickett, namely that it was the clear intention of Parliament in passing the Fatal Accidents Act to deal with lost years claims as well as fatal cases. In Bowden and Crown House maintenance, Master Whittaker adopted a novel solution to the problem. He held it was permissible to enter judgment for damages to be assessed, adjourn the claim until after the victim's death, and then assess damages under the Fatal Accidents Act, which could then include an income dependency. Perhaps surprisingly, this decision was never appealed, and indeed the masters dealing with asbestos claims frequently adopt this course. As we shall see, it may be incompatible with the approach adopted in Head and Culver Heating. What is the loss in a lost years claim? You'll see from the quotations on this slide that the House of Lords in Pickett had to go through all sorts of contortions in an attempt to rationalise their decision. Lord Scarman said that there was no completely satisfactory answer to the objection that a lost years claim was meaningless. Lord Wilberforce said you can't solve the problem by describing what has been lost as an opportunity or a prospect or an expectation, but then went on to hold that allowing lost years claim would be closer to the ordinary man's expectation. What is clear from all the speeches, however, is that the loss in the lost years claim has to be something for which the claimant should and reasonably can be compensated. So you have to be very careful to distinguish between the claimant's own loss and the loss to his dependents. There may be cases where they more or less coincide, but there will also be cases where they are very different, either because there are no dependents or because the quantification of the loss is different. All the way through the speeches in the House of Lords in Pickett is the assumption that lost years claims are claims for loss of earnings in the lost years. Lord Wilberforce said this: is the victim not entitled to say, at one moment, I am a man with existing capability to earn well for 14 years. The next moment, I can only earn less well for 1 year. And why should he be compensated only for the immediate reduction in his earnings and not for the loss of the whole period for which he has been deprived of his ability to earn them? The Australian courts have taken the clear view that the loss is of the capacity to earn money from the use of personal skills. And that was the basis of the decision of the High Court of Australia's case of Amaka and Latz. In that case, the High Court of Australia held by a majority that while a pension from an occupational superannuation scheme could form part of a lost years claim, income from the statutory old age pension scheme could not, because it was not, as it were, the result of the victim's own work. The English cases, such as they are, and there have been remarkably few appellate decisions in lost years claims since Pickett, don't appear to distinguish between earned and unearned pension income. Phipps and Brooks was one of them, where what was under consideration was income from an occupational pension scheme, so that on that basis it could form part of the lost years claim. The 24-year-old claimant in JR and Sheffield teaching hospitals, which I refer to on the slide, also recovered a pension element as part of his lost years claim, although the point about state pension does not appear to have been argued. And in Adset and West, the judge, it was a first instance case only, held that the prospect of the victim's inheritance, had he lived, of his father's share in 2 partnerships could form part of the lost years claim, although he assessed it, and I quote, with moderation. What about losses that are certainly irrecoverable? Phipps and Brooks again, this was a mesothelioma case. The claimant was a married man aged 51 with months to live. Before he became ill, he used to do DIY work around the house and was a keen gardener. He claimed the value of these activities in the last years. Lord Justice Stuart Smith held that it does not follow that because these skills have a value to a plaintiff who is alive and cannot exercise them, so that he has to pay others to perform them, that they have a present value to a living plaintiff in relation to the period after his death. He has not lost anything of value in performing work which would save him expense, which he will never incur. If we contrast that case with the more recent case of Andrew and Booth Horrocks, again on the slide, the claimant was a man who had an extensive vegetable growing enterprise and used to grow food for his wife. He also provided her and the business they ran with services. He was unable to attend trial because of his illness, and so was unable to give detailed evidence as to these services. The judge, in a somewhat ambiguous passage, adjourned the last year's element of the claim until after his death. The implication apparently being that the notional value of services provided to someone else was recoverable as part of the last year's claim. If that's what the judge was in fact saying, it seems questionable whether that was correct. I then touch on a slightly different case, Watson and Cape Bread Roby. Claimants often claim for funeral expenses for living claimants. There was an older case called Bateman and Hydro Agri where they'd been allowed. But I think that the decision in Watson and Cape Bread is a logical one, because if they were allowed in a situation where the living claimant was close to death, then they in principle would be allowed whenever there was a reduction in life expectancy, however slight and however long in the future that might be, because he'd be able to make a claim for his own funeral expenses, and that would plainly be absurd. Deductions. The conventional reduction is 50%, which is based on the proposition that a married man will spend a third of his income on himself, a third on his wife, and a third on joint expenditure, as in a traditional fatal accident claim where there are no children. So on that model, 1/2 of his income is spent effectively for himself, on himself, and so should be deducted. That model might be suitable for the case where the claimant is an elderly man whose wife does not have her own income, and so may well be unobjectionable in many classic mesothelioma cases, but may well not be a correct approach in other cases. Despite that, the starting point of 50% deduction for living expenses has been hard to shift. And in the 40 years since Pickett, there have only been a handful of cases where that conventional reduction has not been adopted. It's probably time for a rethink, not least because in many cases where the victim is an elderly working man, the amount of his occupational or state pension will be small, so that he'll have little left over to spend on what Lord Wilberforce referred to in Pickett as other persons or causes which he wishes to support. The first instance decision in Head and Culver Heating is an interesting recent example of a case where the 50% approach was displaced on the basis of expert accounting evidence. In that case, the victim was a wealthy man with a yacht and a house in the south of France, and it was submitted on his behalf that only 25% deduction for living expenses should be made. In the event, the judge held that the deduction should be 45%, which on the likely figures in that case will result in a sizable difference in the award. We come now to the central topic of investment income. The law on lost years claims, as it's been developed to date, has suffered from some confusion as to whether income from investments, such as dividends on shares, should be taken into account in calculating a lost years claim. As long ago as 1973, the Law Commission report on assessment of damages in personal injury litigation considered that there seems to be no justification in principle, they said, for discrimination between deprivation of earning capacity and deprivation of the capacity otherwise to receive economic benefits. In Pickett, Lord Scarman agreed with that proposition, Thus, for example, the loss of income from an annuity could form part of the claim. But the Law Commission, in its report in 1973, went on to suggest a claimant's income, they said, may, however, come from dividends paid on capital assets, and as these assets will themselves, subject to death duties, be able to pass on his death to his dependents, we consider the court must have a discretion to ignore such lost income. Well, that was, until recently, generally accepted as the law, and on the basis of that reasoning, in Adset and West, the judge held that since the capital remained intact and did not lose its capacity to earn income, such income was not to be taken into account in assessing the last year's claim. Now we have the Court of Appeal decision in Head and Culver Heating, and the position is clearer on the ground, although the conceptual basis, I'm afraid to say, is not. In that case, the victim had set up a heating business many years ago. That was successful, and he remained the driving force behind that business. However, for tax reasons, he chose to take a fairly small salary from the business, and most of his income came from dividends on shares he held in the business. At first instance, it was held that the dividend income could not form part of the last year's claim. On appeal, however, the Court of Appeal held that the dividend income could form part of such a claim because, by parity of reasoning with the first instance decision in Ricks and Paramount Shopfitting, which of course had been decided late last year, it was the result of his hard work and flair and not a result of not a return on passive investment. The actual assessment of the lost year's claim was remitted to a master. In fact, the hearing of the assessment was before Mr. Justice Johnson last week, with judgment not yet handed down. It'll be interesting to see how the quantification of the damages is sorted out. There's clearly a risk that there will be what defendants, at least, would regard as double recovery. That's to say the family will not only have the actual dividend income from the shares, but also the value of the lost year's claim based on that very same dividend income. There remain unresolved issues of principle. There's in fact an interesting, fairly recent High Court case called Shulman and Simon, which I understand was not cited in Head and Culver, either at first instance or in the Court of Appeal. In that case, the claimant was the wife of a wealthy man who was a financial advisor. She was the company secretary in his business and as such was paid a salary. She also had a shareholding in that business, and it was argued on her behalf that her last year's claim should include dividend income on the basis that that income in reality formed part of her earnings. The court, however, held that her contribution to the business was reflected in her salary and not in the dividend income, and that the fact that her husband had chosen to organise his finances in a tax-efficient way by giving her a shareholding did not have the consequence that that should form part of her last year's claim. Part of the rationale of that judgment was that her shareholding would survive her death and so continue to yield income, which now seems untenable in the light of Head and Culver. But what about someone who has, through his hard work and flair, earned money with which he's bought investments from which he was deriving an income? Should his last year's claim include such income? On the one hand, it was indirectly the result of his work. On the other, it is now a passive investment. This is a common difficulty in reality because many people now live on private investments in their retirement rather than on occupational pensions. If, as in Head, survival of the asset for the benefit of others does not prevent recovery, why should such investment income not be recoverable? I mentioned in passing date of assessment. In a fatal accident claim, the position is clear. You assess the loss at the date of death. But at what date do you assess the loss in a last year's claim? In Head and Culver itself, Lord Justice Bean referred at one point to the position at the time of the claimant's diagnosis. It was a mesothelioma case. At another, to the position at the date of his death, because he'd in fact died by the time that the claim came before the Court of Appeal. In principle, it should be the date of trial, but of course by then the victim may well have changed his financial arrangements in anticipation of his death. So that problem remains unresolved. Can I just mention a few practical issues? In most cases, the court is not going to be persuaded to budge from the conventional 50% discount for living expenses. But what about the case where the claimant is a wealthy person who has a lot of spare cash, much of which he spends on himself, yachts, motor racing, etc.? Should you discount the lost year's claim by the amount of luxury spending on himself or not? In Pickett itself, Lord Wilberforce postulated the situation of a claimant who says, what is of value to me is not only my opportunity to spend my earnings enjoyably, but to use such part of them as I do not need for my dependents or for other persons or causes which I wish to support. On that basis, one should not reduce the multiplicand for non-essential expenditure by the claimant on himself. But in both Asset and West and Head and Culver Heating, the court did discount from the multiplicand the amount spent by the claimant on his own pleasures as well as on his core living expenses. As I've said, the devil of quantification will be in the detail. If the quantification is after the death of the victim, as is the case in Head, the court will be able to look at the actual position. And if the business is no less profitable, it'll be open to the defendant to argue that the dividend income did not result from the victim's hard work or flair, but was in reality a return on a passive investment. Just by way of a tailpiece, I mentioned the question of survival of lost year's claims. As you can see from the slide, it's well established that a lost year's claim cannot now survive the victim's death so as to form part of the estate. In Head, the claimant was alive at the time when judgment for damages to be assessed was entered by the master. He was still alive at the first instance hearing of his assessment of damages before the High Court, but had died by the time the matter came before the Court of Appeal, and the appeal was continued by his widow as executrix of his estate. No point was taken on this by the defendant, but I wonder whether it could be argued that if Bowden and Crown House was correctly decided, the claim should have continued as a fatal accident rather than a lost year's claim. So despite the apparent clarity of the decision in Head and Culver Heating, many interesting and logically challenging issues remain for argument. Paige and I were glad that you've joined us for this talk. If you've got any queries, please let us know by email. We'd usually say at the end of a 2TG seminar, please join us for a drink. We hope you'll be able to do so in the not too distant future. In the meantime, keep safe and we'll see you soon. Thank you very much for coming along. Goodbye.